All right, I hope you can hear me. Just waiting for the rest of you to confirm your presence, and then we'll begin. So we'll try to finish this today. I think we should be able to, right? So just confirm that you're here, and then we can begin as soon as enough people have joined. I don't know who all is, who all are here. I just know that there are two people currently viewing this feed. But so whoever joins, just please just confirm that you're present, so that I know that you're all here, right? And we'll begin as soon as everybody joins. Meanwhile, for those of you who are present, if you have any questions about what was covered yesterday, or if you have any questions about the course generally, or anything else, just let me know, right? While we just wait for the rest to join. All right? I'll just write down that we're going to begin at. We'll begin at. Let me see what time we have right now. We'll begin in 2 minutes either way, so that we're able to finish this. I don't know how many of you are going to be attending this, right? So we will begin at 1:22 p.m. sharp. Right, so let's begin. If you have any questions, just make sure that you write them down in the comments section, right? I'll get back to you as soon as I read those comments, right? Just a brief recap of what we did yesterday. We're going to hopefully finish Ombudsman today, right? And you will recall that it all started with Critchell Down, right? The Critchell Down affair led to a bit of a crisis in the sense that there was so much wrong with how the government had handled that issue, with, of course, the speeches made in Parliament and whatnot. And so it was in the wake of these key lessons that are here on the slide in front of you, right? The idea that members of parliament are not strong enough or are not effective enough to hold the executive to account, or at least not to hold ministers to account in particular, right? And judicial review is too much of an extreme to be relying on. This was the reason why ombudsmen in the first place came into being, right? And you do know about their Swedish origins. You know that they are basically meant to investigate officials, and they're meant to be independent of the people that they investigate. You also know that the problem that did arise, of course, was the fact that it was contrary to British tradition. British tradition demands that MPs are the ones that you take your grievances to. The idea that you could take your grievances to someone other than your MP was going to be quite problematic. And so to overcome that problem, you know that the solution preferred was to make the ombudsman parliamentary in three ways: to add an MP filter, which means that an ombudsman can only start if he or she knows, for that matter, that the complaint has come from an MP. You can't directly petition the ombudsman, as it were. Similarly, they required the ombudsman to report to Parliament, and then also provided the ombudsman with adequate support, in the sense that the committees were the ones that were going to actually hold them to account and actually listen to what they had to say, right? So with that development, you also know then we've gone through the bare bones of this, right? The idea of who the ombudsman is, whom they can investigate, how she proceeds, what they can't investigate, the time limit for bringing a complaint, how does she proceed, and we know that in a nutshell, the key things that you have to keep in mind are here in front of you on this slide, right? Independence, investigative process, their task, as well as their reporting function, right? Very important to remember these salient features of the ombudsman, because that's how they function. And we looked at the debt of honor investigation and how that showed both the downside as well as the upside of having an ombudsman decide cases, or having an ombudsman act as a grievance redressal mechanism. And well, I'm not going to go over the debt of honor investigation again, but you do know what was eventually held. And I think this is where we stopped yesterday. We looked at how the local government ombudsman is different from the parliamentary ombudsman, right? So if there are any questions, of course, like I said, you can raise them in the comments here, and I'll get back to you as soon as possible. When this is over, I'll save this and I'll start a new feed which you can join if we have any other questions, right? So even if you're unable to ask a question during this presentation, you can raise a question afterwards as well. What we're looking at today, or where we're starting from, of course, is the maladministration concept, because this is what the ombudsman can check. The ombudsman is not empowered to check unlawful administration. The ombudsman's concept, or the ombudsman's power, jurisdiction rather, is to check for maladministration. And I think Larabe yesterday, for instance, asked, or was it, I think it was her who asked, what is maladministration, right? And I said to you that it is simply bad administration, but it's not been defined. And that's an important part. Legislation does not define the maladministration concept. This lack of a definition is perceived to be deliberate. The idea is that you should let the ombudsman decide for him or herself what she feels is bad administration, rather than curtailing her powers or confining her discretion in that regard, right? So although you don't have a statutory definition, what you do have is Richard Crossman, who gave what we today call the Crossman Catalogue, right? And the Crossman Catalogue is straightforward in terms of what it is. He said that it would be a fun exercise to try and come up with all of those factors that lead to a finding of maladministration, but it would be an exercise in futility. We cannot give a definitive meaning to maladministration, but we do know that maladministration includes the following, and he says: bias, neglect, inattention, delay, incompetence, inaptitude, perversity, turpitude, arbitrariness, and so on. Now, immediately, to the discerning eye or the discerning listener, you will see that there is going to be some degree of overlap between unlawfulness and maladministration, right? And for that very reason, there's going to be some overlap between when a particular grievance can be redressed through judicial review and when it can be redressed through a complaint to the ombudsman. But you have to realize, despite those temptations and despite those overlaps, maladministration remains different from unlawful administration. You cannot and are not supposed to equate the two together, right? Despite that overlap, despite the considerable overlap. So the Crossman catalog was helpful, was useful in the sense that it gives you some indication of what the factors are that will determine whether or not maladministration takes place. So you know that you don't just have an ombudsman who's sitting around and just randomly, arbitrarily deciding whether or not she wants to investigate an issue, right? She has to look for these things. And in 1993, for the first time, the parliamentary ombudsman of that time, the parliamentary ombudsman of that time called for, or gave 15 points. She presented an annual report and presented 15 points, which in her view led to findings of maladministration. Again, I'll read these out to you so that you get some idea of what this is like. The 15 points are: unwillingness to treat the complainant as a person with rights. It's a very specific claim, but I think we understand what she's trying to say. She's probably trying to talk about the dignity aspect of things. Refusal to answer reasonable questions. Remember, we're talking about this conduct of public authorities, or not public authorities, government agencies in particular, right? If a government agency is unwilling to treat you as a person with rights, if they refuse to answer your reasonable questions, neglecting to inform a complainant on request of his or her rights or entitlement, knowingly giving misleading or inadequate advice, ignoring valid advice, or overruling considerations which would produce an uncomfortable result for the overruler, offering no redress, showing bias, omission to notify those who thereby lose a right of appeal, refusal to inform adequately of the right of appeal, faulty procedures, failure by management to monitor compliance with adequate procedures, cavalier disregard of guidance which is intended to be followed in the interest of equitable treatment of those who use a service, partiality, and failure to mitigate the effects of rigid adherence to the letter of the law, where that produces manifestly inequitable treatment. Now, I know how you all think, right? You do not have to memorize these 15 points. I will just write this down for you as well in bold so that you are clear on this and you don't faint with the prospect of having to do that, right? You don't have to memorize these, of course. The sole purpose of knowing these 15 points is to simply give you some indication of, or some of the flavor of what sort of maladministration the parliamentary ombudsman looks at, right? So we're not in the realm of unlawfulness. We're in the realm of badness. We're in the realm of bad conduct, things that are ways of administration that are frowned upon or that nobody ought to actually adhere to, right? So this, at a bare minimum, of course, shows to you that maladministration is a very flexible concept, and it gives you a lot of freedom to play around with a number of things. And unsurprisingly, maladministration has found itself in courts. It found itself firstly through Lord Denning, right? Lord Denning, in the case of Bradford Metropolitan City Council, rightly said that Parliament did not define maladministration, and that this lack of a definition was deliberate. It is for the ombudsman himself to interpret the word as best as he could. So you can see that that latitude and that autonomy is being recognized even by courts. They have resisted the temptation of dictating to the ombudsman what is and is not maladministration. Lord Donaldson made similar claims in the case of Eastleigh Borough Council, right? He was of the view that when it comes to maladministration, it's got nothing to do with the nature, quality, or reasonableness of the decision itself. Of course, if the nature, quality, or reasonableness of the decision is in challenge, then you have a remedy before through judicial review. You don't have to go through to the ombudsman. The ombudsman's task is confined to maladministration, though it may overlap with unlawfulness, and that overlap will come up shortly, right? You'll see where that comes in. So, with that in mind, let's just look at couple of important cases that you need to be familiar with. The first is the Liverpool City Council case, right? Let's go with the facts of this so you understand where it comes from. Liverpool City Council gave planning permission for a new football stand at a stadium, right? That planning permission was granted, and thereafter, several people went and complained on the basis that the council members, the Liverpool City Council, who had actually granted this permission, most of these members were either season ticket holders or they regularly attended matches. Of course, their inclination or the implication that was sought to be drawn by these complaints was that the councillors were biased. They were biased in their decision to grant planning permission. They shouldn't have been the ones deciding this because they had an interest, in the sense that they were season ticket holders or they regularly attended matches. Now, since this is to do with the Liverpool City Council, right, you would realize that the complaint went to the local government ombudsman and not to the parliamentary ombudsman. The local government ombudsman made an adverse report, right, and she said that the councillors should have disclosed their interests at the time when they were making or adjudicating upon this application for planning permission. The fact that these interests were not disclosed means that the decision was tainted with bias, right? And therefore, according to the Liverpool City Council, the recommendation, according to the Ombudsman, she made the recommendation that this ought to be considered by an independent person, and it is maladministration on the part of Liverpool to have actually done what it did. Now, this would have been unremarkable had it stopped there, but Liverpool City Council was livid with the suggestion that they were biased, or with the suggestion that they were bound to disclose their interests in Avonfield as season ticket holders. And so they went in judicial review of the Ombudsman's report, right? Now, it's all well and good to think that with Ombudsman you could somehow ease the burden of courts, but it's not so. You will see that courts have been dragged in to the Ombudsman process more often than not, and that has actually led to is one of the severe shortcomings of the Ombudsman process. The relevant part of the claim that was made by Liverpool before in judicial review was that the Ombudsman erred when she applied the test of bias that she did in the case itself. What she ought to have done was she ought to have relied on the test of bias developed in judicial review. And you will recall, since we've just done bias, that test was quite difficult to meet, right? Because remember, it was 2001, and this is a time before Porter and McGill. Porter and McGill came at the very latter part of 2001. And before Porter and McGill, of course, you had the real danger of bias test as modified modestly, so to speak, in re medicaments. So this was the claim. The claim was that the Ombudsman erred in judging whether or not we engaged in maladministration. She should have applied the test for bias developed in judicial review. Now, before I tell you what the Court of Appeal held in this case, you will know that if the Court of Appeal were tempted to actually agree with the council, then they would have run the risk of equating judicial review with the Ombudsman process, because you only need to apply the test for bias as developed in judicial review if maladministration is the very same thing that judicial review checks. But judicial review does not check maladministration, does it? Judicial review checks unlawful administration, or judicial review checks jurisdictional defects. So if the Court of Appeal had unequivocally agreed with the City Council, then they would have blurred the distinction between maladministration and unlawful administration. And that is precisely why the Court of Appeal held that there is an overlap between maladministration and unlawfulness, just as I pointed out. But when you determine maladministration, you don't have to take the same things into account as you have to do when you're determining lawfulness, right? And you don't need to hold that the Ombudsman must be constrained by the same legal principles as a court of law is to be constrained with when they're deciding on the legality. So, in sum, the Liverpool City Council case shows you that despite their overlap, the techniques, the tests, as well as the process to be used by the Ombudsman is not meant to be identical to that used by courts, right? I hope this point is clear. If it's not, you're of course welcome to raise a question in the comments, right? But I'm assuming until I receive such a question that it is clear. So we can proceed. despite the different procedures as recognized in Liverpool, you cannot overlook the fact that there is nevertheless a link between maladministration and unlawful administration, right? And that link is best illustrated by the debt of honor saga itself. We've talked about debt of honor yesterday. You would recall that it was a scheme announced by the government that they were going to pay £10,000 to all of those British civilian internees who had been interned by the Japanese during World War II. You will also recall that they introduced a blood link test so that you could only be eligible or could only be called a British citizen if you were either born in the UK or one of your parents or grandparents were born in the UK. And quite apart from the ombudsman proceedings, there was also judicial review proceedings. And you recall that we've done the Absifer case when we were looking at legitimate expectation. The argument made in Absifer was that British civilians in general, those who had been interned by the Japanese, when the minister took the floor of the House and announced that he was going to make payments to British civilians, he created a legitimate expectation. A legitimate expectation in favor of those people who thought that they were going to be entitled to these payments, right? I was assuming, had yesterday's class been not been a remote class, but been an interactive class, then you probably would have highlighted that, or would have at least questioned, I'm sure would have questioned why legitimate expectation was not pleaded or was not argued. Well, the answer to that is in front of you. The High Court was of the view that what the minister used was woolly language or vague language. He did not give what we call a clear and unequivocal representation. Simply to go to the floor of the House and say that we're going to give compensation to those British civilians who've been interned by the Japanese in World War II, that is not clear and unequivocal enough according to the High Court. That was what Absifer held. Now, so the outcome therefore is that whatever else was wrong with the debt of honor, thing, it was not unlawful what was done. But the ombudsman relied precisely on the court's decision and said this is exactly why there is maladministration in the debt of honor saga, right? In the case of Professor Jack Hayward and people like him, because of the lack of clarity. To take the floor of the House and make woolly statements without clarity, it represents departure from standards of good administration. And since it represents departure from standards of good administration, it qualifies or constitutes maladministration, according to the ombudsman. So you can understand, therefore, the interplay here. That same lack of clarity, which saved the government from a claim of legitimate expectation, ended up being the death knell to it when it comes to the ombudsman's report, right? The ombudsman says that it's that very lack of clarity which means that you engage in maladministration. If you want to engage in good administration, you should have made clear, unequivocal, self-explanatory statements so that people are not misled to believe things that are obviously not true. And of course, the debt of honor saga didn't end there. There was also a case that went all the way up to the Court of Appeal in Elias and Defense Secretary, right? In this particular case, it was held that the blood link test is in fact violative of Section 1, subsection 1, Clause B of the Race Relations Act, because it amounts to a form of indirect race discrimination, right? This is eventually where the blood link test met its fate at the end from the judicial side of it, right? But what are the key takeaways from the debt of honor litigation, as it were? Well, the key takeaway from Elias, at least, that you have to realize is that only a court of law could have declared the blood link test to amount to indirect racial discrimination, right? The ombudsman does not have the jurisdiction to say that indirect racial discrimination amounts to maladministration, right? Now, the ombudsman could have tentatively concluded that, yes, this is indirect racial discrimination, it is violative of Race Relations Act 1976, but that in and of itself was not enough to call it or bring it within the purview of bad administration. I hope you understand this, right? Because again, it's just illustrative of the interplay between these two things. A court of law can declare it unlawful, and an ombudsman can't rely simply on unlawfulness to call it maladministration. If it's unlawful in terms of a statute, then it is only for a court of law to declare it to be unlawful in that sense, right? Second thing, of course, to note is that the ombudsman's jurisdiction has a wider remit than that of judicial review. Because remember, go back to Absifer, as I just pointed out briefly. In Absifer, legitimate expectation failed. There was no successful claim of legitimate expectation, so there was no unlawful conduct by the minister. Yet, there was maladministration on his part, right? And this therefore goes on to reinforce our central point that maladministration is distinct from unlawfulness. This was stated for the first time, well, it was stated by Denning as well, as we discussed, but in Congreve and Home Office this was pointed out, and it remains true to this day, right? Despite their overlaps, maladministration and unlawfulness are not to be equated. If there are any questions on this, again, you're welcome to raise them in the comment section, right? I will confess that I have no way. Let me just check if I can see whether there are people on this feed. Yeah, there are 7 people on this feed. I don't know who, but let's assume that you're all watching and listening, right? So yeah, any questions, you feel free to raise them. Let's move on to a different issue then. It's not just maladministration that is sufficient for a complainant to succeed before an ombudsman. The complainant must also show that he or she suffered injustice in consequence of maladministration. This is provided for in Section 5, subsection 1 of the Parliamentary Commissioner Act of 1967. And you will therefore appreciate that this is more or less a requirement of standing, right? Just like, I mean, I can't just simply walk up to an ombudsman and complain just because there's been maladministration. I must additionally show that I suffered some sort of injustice. This is a requirement of standing. If I have not suffered injustice, the ombudsman will not investigate my case, is likely to happen. And you will also appreciate, therefore, that this is a far more stringent requirement than that in judicial review. Judicial review, as you've done, and you must be revising in full force now, the law of standing, that only requires you to prove that you had or allege that you had a sufficient interest in the proceedings. You don't have to be directly affected by them. But when it comes to maladministration, that is something that is different. Sorry, I have a question. It said, shouldn't unlawful action always amount to maladministration, since a properly administered public authority wouldn't behave unlawfully? It's a good point, Zainab. I would definitely support that view. But the fact of it is that despite the intuitive appeal of the view that you've just stated, it is still recognized that there are scenarios where unlawful action might not amount to maladministration. Why? Not because the action is unlawful. We have to wait for a declaration of that unlawfulness. You understand this? So the ombudsman could not have declared on herself or through herself that this is that this is unlawful. If unlawfulness is declared first, then that can amount to maladministration, right? So to say that it's maladministration without that declaration would be putting the cart before the horse, right? So yes, in general, you are right. The actual way of looking at this should be that unlawfulness is always going to be equivalent or equal to maladministration, yes. But the crucial caveat is you must first get such a declaration of unlawfulness. That declaration can only be issued by a court and not by the ombudsman, him or herself, right? To put it differently, if I had complained to the ombudsman that this is racial discrimination, she would have dismissed my claim and said, I can't call it maladministration because it is racially discriminatory, right? You must first get that declaration from a court of law. I hope that answers the question, right? If there are further questions, please feel free to raise them. Back to the injustice requirement then. So it's not just anyone who can put this forward, right? It has to be somebody who suffered injustice. And you can understand that how do you therefore interpret this? The requirement is likely to be met if the person in question has actually been affected by the maladministration. But let's look at, let's look at Jack Hayward again, Professor Jack Hayward, right? Professor Hayward was not directly affected when you think about it, in the sense that he did not have a right to claim, right? He did not have a financial stake in it. At best, it was a discretionary thing that he did not eventually get. but he did not have the cause to stand up to anyone and to say that, well, look, this is what happened, and I have a right to get compensation in my favor, right? You will understand how that works. So he had no right to a payment. He would not necessarily have received a payment even if his application had been considered. But what the ombudsman decided was that the reason why Professor Hayward falls within the realm of one who has suffered injustice in consequence of maladministration is because he and others suffered outrage, and the outrage and distress that was caused constitutes injustice. Now, this is a problematic view. It's one that has been criticized extensively by Timothy Endicott, right? But it's not novel. It's not something that the ombudsman in the debt of honor investigation came up with herself. The idea that you can suffer, that if you suffer outrage at injustice, that if you suffer outrage rather, and that amounts to injustice, this idea finds support firstly from the Crossman catalog, as well as from the Bolchian litigation that we will do towards the very end of this particular class, right? Endicott is, of course, critical of this. There you can finally see Endicott in his worst of moods at the bottom right of your screens. His view is outrage is a person's response to a decision. It is not injustice in and of itself. Frankly, he has a point, right? If the requirement is injustice, you should not be looking at the reaction or the response to a decision and base a conclusion off of that. You have to realize that the statutory term can't be nullified in this particular way. And so his alternative is to instead prefer an interpretation where you say that the person who has suffered injustice in consequence of maladministration has to be someone who is a victim of maladministration, or that he or she must have suffered some prejudice, right? This seems to be, Endicott at least is of the view that this seems to be more coherent with the purpose of the statute, right? Either way, you are not entitled to a remedy or you're not entitled to petition the ombudsman unless you can show that you've suffered injustice. Now, the debt of honor saga shows you that requirement of injustice has been interpreted quite generously in the terms of even suffering outrage is enough. I mean, I could literally walk up and say, look, what happened to Professor Hayward is so wrong. He's a man who's lived in England all his life. He is, apart from that intern period, right, and he has red hair, he's given back to society. I am outraged by the injustice that has been caused to him. And that sense of outrage might itself constitute injustice, and maybe I might be able to surpass that threshold given in section 5.1a, right? Endicott says that this is not desirable. It should not be so straightforward. You should have something more akin to a requirement of having a victim before you, right? Any questions on this aspect of it, please feel free to raise them. Otherwise, I'm moving on, assuming that you're clear on this for now. What are the remedies that an ombudsman can give? You've already talked about this, but let's just have this out in the open so that you're clear. Because remember, from an exam perspective, right, I believe I've highlighted this yesterday as well, you are not going to be called upon to just explain everything that the ombudsman does. Your examiner will assume that you know what he does. Rather, your task and the pattern of questions is the ombudsman tweaked to the right level or tuned to the right level? Is there any change that you need to make? What are the drawbacks of using the ombudsman as a source for grievance redressal? Those are the sort of questions that you would look at. So let's just quickly summarize this for you. You know, firstly, that neither the parliamentary ombudsman nor the local government ombudsman, let me write this down for you because you will or may not be able to add two and two with this, right? The PO stands for parliamentary ombudsman and LGO stands for local government ombudsman. An ombudsman cannot direct a public authority to act in a particular way. That can only be done by a court of law through a mandamus sort of writ or through judicial review. An ombudsman rather cannot go to the public authority and say that you have to do this. What they do have, though, is the power to report, right? To issue reports to Parliament or even to the relevant local authority if you're looking at the local government ombudsman, right? But so that's as far as their powers go. You can report to Parliament. Those reports, of course, are unenforceable, but you must appreciate that the statistics suggest that despite their unenforceability, the compliance rate of those reports is quite high, right? So even though in theory it's not a very potent remedy, in practice this remedy is going to be is something that is worked out quite often, right? So if there are any questions then about how ombudsmen work and how these things, what the reporting function is, please raise them now. We can discuss them. Otherwise, we can move on and look at the case law, right? Because there is a substantial amount of case law. Well, not substantial amount, but there's a protracted litigation that you need to go through in order to complete this, right? So I'm just going to move on, and if I do come across a question from you, I will pause and answer as soon as I do, right? Excuse me. A good starting point, of course, is the Bradley crisis. Let's look at this in a bit more detail. Bradley is a very important case. What happened was that there were a number of pensioners who were expecting to get a certain amount of pension at the time of their retirement. They were led to believe that they would get that amount of pension by virtue of certain discussions had with them, as well as by virtue of certain leaflets that had been published by the Department for Work and Pensions. Now, the Parliamentary Ombudsman was obviously approached when these pensioners didn't get the amount that they were expecting. And the Parliamentary Ombudsman was of the view that the Department for Work and Pensions has committed maladministration. The reason why they've committed maladministration is because they did not accurately explain private occupational pension schemes to the public. Additionally, the leaflets that they used were condemned. Those leaflets were, and you can, I hope you can read this, it's in front of you, that they were sometimes inaccurate, often incomplete, largely inconsistent, and therefore misleading, right? You can say this about literally any judgment in this country these days, right? But that's a bad joke for a different day. Parliamentary Ombudsman, therefore, on the basis of that finding of maladministration, made two recommendations. Again, those are right in front of you. The first recommendation was restore a part of that pension funding so that at least some of those people who were expecting a certain level of pensions, at least they can be satisfied, right? That's the first thing that was recommended. And the second recommendation was why don't you consider making consolation payments to the members so that those who have lost out on this particular on their particular pensions might feel some sense of vindication, right? I may pause and point out that if these recommendations were affected, they would have caused a massive sum of money to have to be devoted towards these pensions. Some estimate this in the figure, around the figure of £3 billion, right? Others have a more moderate estimate. But either way, it was a significant sum of money if these recommendations were to be upheld. But the Parliamentary Ombudsman and the department locked horns on this. The department decided that it was neither going to accept the recommendations made by the Ombudsman, nor was it going to accept the finding of maladministration. Their view was, firstly, that our leaflets were not misleading, and secondly, that there is no indication that these people would have been better off, that the pensioners would have been better off had they been provided with more complete information. And so the department sought to obviously dispute the report, right? And you will know from what we talked about so far that when an ombudsman's report is not accepted, then the ombudsman has the power to lay forward or lay a special report under Section 10, subsection 3 before Parliament, and that is exactly what the ombudsman did in this case. She laid her adverse report before Parliament, and she also expressed her disappointment in the government trying to revisit and reinterpret her findings of maladministration. Re-looking at the evidence, she said that amounts to usurpation of the function that has been conferred upon me. It is not open for the Department of Work and Pensions to revisit all of that. And the same was said by the Public Administration Committee of the House of Commons. They too said that we are disappointed that the government has chosen to act as judge on its own behalf by rejecting and qualifying a number of the Ombudsman's findings, right? So, and to make matters worse, the Bradley crisis spilled over to courts. The dissatisfied pensioners, in fact, were the first ones to go into judicial review. They went to judicial review against the government's decision to reject the Parliamentary Ombudsman's report. They basically claim that it was not open for the minister to reject those findings, right? And the High Court at first instance held that the minister was not legally bound to follow the Ombudsman's recommendations. This is important, right? Because this is still the law. A minister is not legally bound to follow the Ombudsman's recommendations. But the High Court said that he or she was nevertheless legally bound to accept the findings of maladministration. The only instance in which those findings of maladministration can be rejected is if it could be showed objectively that those findings were flawed, irrational, peripheral, or that there was genuine, fresh evidence to be considered. Now, this is problematic, to be fair. The High Court here is being problematic because what it is basically saying is that if I'm a minister, right, and an ombudsman reports against me, makes a recommendation, gives a finding of maladministration, I would now be tempted to challenge that report before the High Court and say, look, it's very unreasonable, it is irrational, right? I might as well take my chances in judicial review, because if I'm a minister, I will have recourse to public funds, right? I'm not going to be deterred by lack of legal aid and whatnot. So the High Court, without realizing, was going down a slippery slope in trying to recommend that an ombudsman's findings of maladministration are generally binding, but are generally final, but if you can show that they were irrational, unreasonable, peripheral, and whatnot, then you have a chance of succeeding. The same argument was made in the Court of Appeal on behalf of the Parliamentary Ombudsman. The Parliamentary Ombudsman argued that the minister must always proceed on the basis that the ombudsman's findings are correct, and the only instance or the only possibility that should be available for a minister to reject those findings is by having them quashed in judicial review. I hope you understand how this works, right? Parliamentary Ombudsman is saying that if we find that there has been maladministration, these findings are bound to be accepted. If the minister seeks to reject them, he must first get them quashed in judicial review. This was the argument made by the Parliamentary Ombudsman. However, the Court of Appeal unanimously overruled and rejected that argument, overruled the High Court's approach in this, and said that it is not necessarily unlawful for the public authority to reject the ombudsman's conclusions, even if those conclusions were rational, right? Because the judges were of the view that if we follow what the Parliamentary Ombudsman is saying, and if we follow the High Court, then we'll be encouraging the Ombudsman's report to constantly be challenged in judicial review. That is not what the remit of the 1967 Act was. If you go back to the constitutional context in which the 1967 Act came into being, the very purpose behind the 1967 Act was to plug the gap in the grievance redressal chain, right? On the one hand, you had ministerial accountability or ministerial responsibility. On the other hand, you had judicial review. And there was a gap in investigating ministerial misconduct. That is why the 67 Act came into being. If you want to bring judicial review into this, then you are essentially defeating what the purpose of the Act was. And so the most crucial qualification, though, came from the Court of Appeal. That's the last point on this slide before you, right? They nevertheless upheld the conclusion of the High Court that the minister, in refusing or rejecting the Parliamentary Ombudsman's report, had acted unlawfully. The reason why this finding of unlawfulness was given was because, in the court's view, if a minister wants to reject an ombudsman's report, that rejection has to be based on cogent reasons. That is the test that is still applicable today. Today, you can reject an ombudsman's report, but only if that rejection is based on cogent reasons. No marks for guessing, of course, that with due respect, they have perhaps botched this up a bit, because how do you decide whether the minister's decision was based on cogent reasons or not? Well, surprise, surprise, judicial review. So despite saying that we don't want to judicialize or over-judicialize the process, the fact that you still can reject it on the basis of cogent reasons means that judicial review will nevertheless be part of it, right? I hope the Bradley litigation is clear so far. Again, if you have questions, please do feel free to raise them. I'll proceed into onto the aftermath of the Bradley litigation, right? what happened thereafter was that the parliamentary ombudsman in 2010 once again laid a report before Parliament and said that that whatever has been done so far by the government to redress their maladministration has not been enough. They've not taken enough steps. And so the Labour government of that time accepted the findings of maladministration, but they only proposed a limited compensation scheme, right? And subsequently, a coalition government was formed. That coalition government agreed to implement the Ombudsman's recommendations and make fair and equitable payments to equitable life policy holders. Now, again, this is not a blanket acceptance of what the Ombudsman had recommended, but again, it is better than nothing. These were based then on a statute. A statute was enacted to deal with the crisis. That statute set aside a sum of £1.5 billion for the purpose of meeting these compensation requirements. But as I said again, this was not even nearly enough to remedy what had actually been done, what was actually expected by those pensioners, right? So, sorry, let me just proceed with this. Let's look at the key takeaways then from Bradley. See if I'm the right. So yeah, right. So again, let's just go through this point by point, right, and see how this actually works out. According to Bradley, then, a minister's response can only be deemed unlawful if no reasonable Secretary of State could rationally disagree with the Ombudsman's findings, right? And so this, you will appreciate, then does not require the minister to do as the Ombudsman has recommended, right? All it does is that the Ombudsman was only bound to make a fresh decision. That the minister rather was only required to make a fresh decision on the basis that the leaflets were perhaps misleading. It doesn't go the full Monty, is the point, right? You don't have to do the entire thing in order for that to work. And so Bradley is therefore problematic. Endicott is of the view that you should never have involved courts into this entire process in the first place. Why were the courts involved in Bradley type cases? Bradley doesn't tell us why courts were involved in the first place, right? And whether it's a simple application of Wensbury, again, remains to be seen. But there definitely is a gap to be bridged in deciding why courts are brought in the first place to a case like Bradley. And so what you have to understand is when you say that a minister has to follow the findings of the Ombudsman unless they were unless there are cogent reasons to not have to follow them, then the danger of that is that you are falling into the pitfall of merits review, right? This is exactly what happened in Bradley, because it was up to the Court of Appeal, and they engaged in a lengthy, about 12 paragraph long discussion of why those leaflets were actually quite misleading, right? And that it was therefore irrational on the part of the minister to reject the Ombudsman's findings. Now, Endicott is critical of this, and I believe rightly so, because what now happens is, if I'm a minister, right, and there's a finding of maladministration against me, I seek to dispute it. I say I don't want to follow it because the findings are unreasonable. They're Wensbury irrational. When the matter goes before the court, then the court has to see that did the Ombudsman actually get it right. And when the court has to see whether the Ombudsman got it right, they will inevitably have to step into the merits of it, which is exactly what they did in Bradley, right? So Endicott's basic beef with Bradley is that the idea of the parliamentary ombudsman was that you decide things in the parliamentary arena and not in the judicial arena, right? Yet Bradley is now encouraging claimants to drag the matter into the judicial arena and get a new inquiry from the judges on those same facts, right? This is not desirable. This is something that ought to be remedied when it can, but as it stands today, Bradley is still good law, right? In terms of impact, you will see again from the slides, from the slide on the board, two cases very briefly. There's the Equitable Members Action Group case, where Bradley was followed. The Bradley test of cogent reasons was followed. In that case, a government had responded adversely to an ombudsman's report, and the complainant challenged that before court, and the court applied the cogent reasons test and held that no, the government did not have cogent reasons to reject the ombudsman's findings, right? Again, this just vindicates Endicott's point that complainants who are not satisfied by the ombudsman process, because let's suppose the ombudsman decided in their favor, yet nothing was done about it, now they can also go to the court and persuade a court to somehow make sure that the government is bound to accept the findings as it turns out. The other case that you have to note is the Gallagher case, Gallagher and Basildon District Council, right? This refers to, sorry, this concerns the local government ombudsman, where it was held that it was necessary for a local authority to demonstrate that it was reasonable for it to refuse recommendations, right? You don't need to know these two cases in significant detail. What you have to know, or at a bare minimum, is that Bradley is good law. Bradley tells you that the refusal to follow a report of an ombudsman has to be backed by cogent reasons, right? So if there's any question on this, please, I repeat, feel free to raise them here, and I can discuss them as soon as I receive them, right? But moving on from here, we're now looking at the judicial control over the jurisdiction of ombudsman, right? And judicial control, as you can see, has generally been limited. First of all, just like any other authority, the parliamentary ombudsman as well as the local government ombudsman both are creatures of statute. So just like a public authority can commit a jurisdictional error, so too can a parliamentary ombudsman. But there's a crucial difference, right? If a parliamentary ombudsman refuses to investigate, courts will be very reluctant to intervene. This was highlighted for the first time in the case of Reeve Fletcher, right? Which went all the way up to the Court of Appeal, and then leave to appeal was refused by the House of Lords. But the decision is quite important. It said that the 1967 Act confers a very wide discretion on the ombudsman. It is for the ombudsman to decide whether he wants to investigate or not. Courts will not make that decision for him, right? So judicial review of the ombudsman's decision to review or not review is fairly limited when it comes to jurisdictional error of that nature, right? And again, you will recall Liverpool City Council, where the Court of Appeal refused to quash the ombudsman's finding of maladministration. And then finally, the last case on this slide is the case of Ex parte Dyer, where a complainant sought a judicial review. The complainant had applied for the reopening of an investigation because he was dissatisfied with the initial investigation made by the ombudsman. He tried to argue that that investigation should be reopened, but the ombudsman refused. The High Court upheld the ombudsman's decision. This is Lord Justice Simon Brown in the High Court, right? He was of the view that courts will not readily interfere with the broad discretion that has been conferred upon ombudsman, right? Same as was held in Reeve Fletcher. It is for the ombudsman, him or herself, to decide how she wants to limit the scope of her inquiry, whether or not she wants to share reports, whether or not she wants to enter into investigations. These are all things that the statute has designated for the ombudsman, him or herself. Therefore, it is not for courts to actually intervene in these types of cases, right? So, I mean, you will understand that as a general rule, courts are going to be very reluctant to interfere in the jurisdiction of the ombudsman. However, they did interfere considerably in the Balchin litigation, right? This will take a while, so just try and understand this as best as you can. The Balchin litigation revolved around Norfolk County Council and the Balchins. The Balchins lived in a house called Swans Harbour. Norfolk County Council decided to build a bypass very near to their house. This caused planning blight, and planning blight I should explain to you. I'll just write this down for you so that you are clear on this, right? refers to the reduction in market value of property due to development nearby, right? Sorry, just got to get the spellings of this right. Right, the reduction in the market value of property due to development. Ignore the right at the end of development. The idea is when you have a bypass literally 2 meters next to your house, then your house is going to lose its value. It's going to lose its value for the simple reason that it's not going to have the same amount of privacy. It's not going to fetch the same amount of market value either way, right? And so because of that, because of this planning blight, the Baltians are obviously quite upset. To make matters worse for them, the bypass was not ever built, but because of the reduction in the value of their house, Maurice Baltian, who was the husband and the person in whose name the house was, he lost equity in the house, right? He lost a significant amount of equity that he would have needed if he wanted to secure his business debts. But since the house did not have the same value as it would have prior to that planning permission, Mr. Balchin refused to secure those debts. And you will realize that the county council had a discretion to purchase blighted property, right? They had a discretion to purchase blighted property, but they were under no legal obligation to do so. And unfortunately, in this case, the council did not decide to help out the Balchins. And this is where the Department for the Department for Transport entered the picture, right? The Department of Transport was engaged because they had to confirm or reject a road order that the Secretary of State was the competent authority to deal with. And so when Norfolk applied to the Department for Transport for confirmation, the decision letter that the Department for Transport gave back to Norfolk had an accompanying statement. The inspector for the Department of Transport expressed hopes that the council would treat the Balchians sympathetically. Now remember, just to clarify for this, it is for the county council, for Norfolk County Council, to decide whether they want to buy the Balchians' house or not, right? It is not for the Department for Transport to do that. But the Department for Transport did highlight that you want to look at the Balchians sympathetically, right? That's what they said. In response to this letter, the chief executive of the Norfolk County Council wrote back to the Department of Transport and said that, look, I know that I have a legal duty to consider buying their blighted property, but I have no legal duty to do it out of sympathy. And then he concluded with the following phrase: I do not wish to sound harsh or bureaucratic, but local government is frequently told to act within its powers and to curtail unnecessary expenditure. Now, just to pause here, if you are the Department for Transport and you receive this letter from the Chief Executive of the Council, you know that he is saying in so many words that he has no intention of buying the Balchians' house. But the Balchians complained to the ombudsman, and their complaint was a bit unique. Their complaint was that the Department of Transport has engaged in bad administration. Because if they wanted to engage in good administration, what they should have done was not issue the road order that they did issue eventually, without first getting assurances from Norfolk County Council that the Balchians would be adequately compensated, right? Again, I'll repeat the content of this complaint. The content of this complaint is that the Department of Transport has committed maladministration because they should have sought and received assurances from the Norfolk County Council that the Balchians would receive compensation for their blighted property. And then and only then should they have confirmed the road order, right? Unsurprisingly, the ombudsman found that there was no maladministration in this case. The minister could not have made the order conditional on a sympathetic approach to the Balchians. That's what the ombudsman relied on, right? And therefore, at first instance, of course, at this level, when the first report has come out, it has come out against the Balchians, right? Then came the case. Balchin was then taken to, the Balchins then went in judicial review, Balchin number 1, where Justice Sedley, in a surprising move, held that the Department of Transport, held that the Parliamentary Ombudsman had acted unlawfully. He had acted unlawfully because he had failed to take into account what Justice Sedley called a decisive relevant consideration. That decisive relevant consideration is that the council obviously had a hostile stance towards the Balchins. This is something that the Department of Transport should have realized, and therefore it should have acted accordingly, right? Without this hostile stance of the council being taken into account by the ombudsman, his report is not accurate, or is not good enough to actually dispense with his statutory function. Endicott, of course, is quite critical of this, because Endicott is of the view that, remember, the Department of Transport did point out to the council that you should treat the Balchins sympathetically. So really, to say that they committed maladministration is quite a stretch, given that they had pointed this out. And so what you're basically saying is that the department has committed maladministration in omitting to point out something to the council which they already knew in the first place. Remember, the chief executive wrote back and said, I know that I am under duty to consider, but I don't have to do it just because I have sympathy for the Balchins, right? And Endicott, of course, is quite critical of this particular fact. So in light of the outcome of Balchin number 1, a second report was published by the ombudsman, right? A new ombudsman altogether reconsidered the complaint, and this second ombudsman too found that the Department of Transport had not engaged in maladministration. And no surprise, the Balchins once again sought judicial review. This time, Justice Dyson quashed the ombudsman's report and said that the new ombudsman has failed to give reasons for finding that the Department of Transport did not overlook the council's power, right? So again, you can see they're going around in circles. Whenever something is set aside twice, you need to realize that courts are not going to rest until you give them the decision that they're actually after, right? And so this case is authority for the proposition that an ombudsman must give reasons that address the principal important controversial issues raised by the parties. That's the narrow proposition of this case. But when you put it in this larger context, it looks like it's a high court that is annoyed by the continuing refusal of the ombudsman or the office of the ombudsman to do a particular thing, at least on the facts of this particular case, as it turned out. It doesn't end there. A third ombudsman's report was then published. Now they started to play ball. The third ombudsman found maladministration, but not in respect of the entire complaint. The ombudsman concluded that there was injustice that has been caused to the Balchins, but he recommended that the Department of Transport should simply issue an apology, and that will suffice. And you would not be surprised to learn that judicial review was sought yet again, and once again, in Balchin number 3, the High Court overruled the ombudsman, saying that you did not give sufficient reasons to us as to why you were rejecting part of the complaint and accepting the other part, and why you think that the apology itself is sufficient, right? And in case you're worried that this will go on ad infinitum, the fourth and final report was published as in consequence to the decision in Balchin number 3. This time, the ombudsman collaborated with the parliamentary ombudsman collaborated with the local government ombudsman, right? And finally, in October 2005, which is 13 years after that first letter that the Department of Transport had written to Norfolk County Council, right? 13 years after they had done this, the ombudsman reported maladministration by both the Norfolk County Council as well as the Department of Transport, and recommended that £100,000 must be paid to the Balchins from each level of government. In case you're wondering what the maladministration was, it's right there in front of you so that you can digest it, right? The maladministration consisted of their failure to ensure that they did not knowingly allow councils to mislead themselves as to the intention of any legislation to which the council were obliged to have regard, and to step in to offer a correct interpretation of the current legislative position if the council clearly misrepresented that. So, in a nutshell, then, the Balchin litigation illustrates that once an ombudsman gives a finding, right, and that finding is disputed, the only way that, and of course the finding is quashed in court, the only way of getting out of that then is to give sufficient reasons. Endicott has been highly critical of the decision in Balchin and the Balchin saga itself, right? He's of the view that this was entirely unnecessary. You are bringing in courts into an area where literally the ombudsmen are being micromanaged, right? It was never intended for courts to be able to micromanage ombudsmen in the process or in the manner that is happening now. Endicott even questions whether this now is against the core rationale of judicial review, because remember, judicial review's core rationale is to prevent arbitrary government. And if arbitrary government is what's an issue, why are you going after the ombudsman, who is a statutory functionary, and trying to decide what's relevant and what's not relevant in determining issues of maladministration, right? So what you have to realize, especially from an exam perspective, is that the Balchin litigation is the biggest example of not just the shortcomings of ombudsman, but also how overly judicialized that entire process can become, right? As far as ombudsmen are concerned, the only thing left in this that I haven't included in the slides is a discussion on how to reform them, right? What I will be doing is there's an excellent note compiled by a couple of academic writers on, and it's an updated note from 2019, right? I'll share that with you over email. It's not very lengthy, right? It's 3.5 pages about how ombudsman or the office of the ombudsman ought to be reformed, right? And so we will look at that. I'll share that with you over email. You can just read that 3.5 pager, and if you have any confusions or questions, you can raise them then. What I will do now is I will end this. I'll start a new feed, and we can then discuss the way forward for us now that we're done with ombudsman as well as I'll take questions if there's anything that bothers you about ombudsman that we've covered so far, right? So I'm signing out of this one. Please join the new feed and ask me questions, and let's discuss how we're supposed to proceed forward, right? So, and yes, finally, this will be saved on your on the Group 5 page so that you can read it, go back to the slides when you want to, right? So I'm signing off now.